constitutional remedies, which is about Article 32 and 26. But before we go into the actual content of Article 32 and 26, we thought it's good to give you an overview of the judicial system in a very broad sense. I mean, when we say I'll go to court, or I'll take you to court, or let's go to court. Now, what do we mean by that? So, which court and what kind of case? These are all questions which one has to be bear in mind and also understand, because going to court is okay, but we have to have greater clarity about which court has what kind of powers and what what is the jurisdiction, what is the kind of relief a particular court can give. These are all matters you will have to. It doesn't necessarily mean that if you go to the Supreme Court, you will get the best result. In fact, very often in many cases, the power of the Supreme Court is much less than what the local court in your area could have. So you need to understand these distinctions before rushing to court. So let's first see what is the role of the judiciary that we can broadly look at. Sainthan, just show the next slide. I can operate it. Okay, fine.
Are you able to see the slide?
No, only the first slide is showing.
No, I am supposed to shift. Role of judiciary. Are you not able to see?
I'm not able to see it.
Wait, I'll just stop sharing and start again.
Yeah.
Just give me a second.
Anyway, as just to give you an overall, the top, of course, we all know is the Supreme Court. Then every state has a high court. And then in every district, you also have the district courts. Now, within the district, you'll have what are called the sessions courts or the district courts, which are the highest courts for that district. And under the district's court, you have a mushrooming of courts, which is you have the additional courts, which will take care of. I don't want to go into the other details, but yes, there'll be more than one district court in a district. Then lower down, you will have the magistrates courts or the municipal courts. So broadly in the criminal justice system, the magistrate court, that is a court where, when somebody is arrested, they are produced before the magistrate for remand, and you apply for bail there. And thereafter, yes. So this is the broad hierarchy. So we have a unified judicial system in the sense that, the judgments of the Supreme Court are binding on all the high courts and the rest of the country. I mean, all courts, both high courts and the subordinate judiciary. But each high court is independent of the other. So which means the high court of one state is not bound by the judgments given by a high court of another state. At best, it can have what we in the legal parlance call, it has a persuasive value. It's not binding, but it just has a persuasive value. So as far as a particular state is concerned, the high court is a head, and after that, the highest court. After that, you go to the Supreme Court. Now, as I mentioned, below each high court, you have the subordinate courts at the district level and the taluk level. And these courts that are under the overall supervision of the high courts, both administratively and judicially. The high court is in overall control of these courts. For instance, even the appointment of the judges, the postings and transfer of the judges, even though the salary may be coming from the state, it is a high court which actually is in control of all the subordinate judiciary, and that is essentially keeping in mind the whole constitutional mandate of separation of powers and an independent judiciary. So that is the reason why the provisions in the constitution have been so interpreted, saying that the subordinate judiciary should necessarily come under the control of the high courts. Now, the fourth point here, you would see the specialized tribunals and other authorities which are there, which is different from the regular civil and criminal courts that we generally talk about. So, for instance, we have for all environmental issues, some project is coming up, somebody wants to oppose a project, or somebody is, suffering because of pollution from a particular industry. For all these kind of matters, now in the 2010, you have the National Green Tribunal. Earlier, the powers exercised by the National Green Tribunal were being exercised by the High Court. And so now you have the Green Tribunal, then you have the consumer courts. Again, you have the national, state, and the district level consumer court, the tax tribunals. So you have, then you have the company courts. So apart from the regular court hierarchy, you do have these specialized tribunals, which again, of course, in terms of the judicial hierarchy, they will all be subordinate to the high courts. Those in certain tribunals, the appeal sometimes is provided directly to the Supreme Court, but overall control will still be under the High Court, though the appointment. So I don't want to go into the other nitty-gritties, but because in certain things, there are the green tribunals are also controlled by the appointment process is different from how it is in the other regular courts. In addition to these kind of courts, you also have authorities. Essentially, if you are looking at maybe departmental authorities, all your labor laws, you have the labor commissioners who are the authorities under the various Minimum Wages Act, the labor welfare legislations. So even under the Income Tax Act, you have the income tax officers who will be the first level of, the interface with the people. If you have a problem with your returns, you first go to the income tax officer, and as against the income tax officer's order, you go to the tribunals. So very often you will have quasi-judicial authorities. It's quasi-judicial because they are not part of the judicial hierarchy. They are essentially part of the executive, but they do have some sort of judicial powers to look into certain aspects of jurisdiction which are conferred to them by certain statutes. So that is the next level, which is not present in the slide, but just to give you a broad overview. Yeah, next.
There's two questions.
Yeah.
Shubhasri asked, what does remand mean? And
Yeah.
Ravi asked, where does the Sessions Court come in this hierarchy?
Sessions is at the district level. So when you're talking of the subordinate judiciary, so it's essentially it is the same administrative hierarchy. At the national level is the Supreme Court, state is the High Court, district is the district court. So that's the same hierarchy. And remand is where once a police officer arrests a person, then they have to be sent to the prison. And that process, and within 24 hours, they have to be produced before a magistrate. And the magistrate at that level should actually examine at that point if the prisoner, if the person who has been arrested should be let out. I mean, is there sufficient grounds for their arrest? Can that person be actually let off on bail then and there? Or does it warrant further custody in a prison? So that order, which is sending the person to further custody in the prison, is a remand order. You're remanding them to the prison. Yeah. Next.
Sorry. How can you arrest someone without a warrant?
No, if it's a cognizable offense, you can. That'll be a whole session on CPC and IPC.
Okay, thanks.
So, yeah, but they do have the powers to arrest. Yeah, now I think
there's one more question. Do you want to take it later?
Yeah, the reasoning for the high courts of different states being independent of each other's judgment, and how would the final decision change if all states were allowed to give their judgment? Yes, that's a good question. See, all the high courts are of the same rank. So they are of coordinate jurisdictions. So each high court enjoys the same constitutional supremacy and they are equal. So you can't say that one is bound by the other. So in such instances, whatever a high court decides is the law for that state. And sometimes, yes, you do have conflicting judgments given by different high courts. And then finally, all this will culminate with the Supreme Court. I mean, there have been instances where if there are ongoing cases raising the same question of law in several high courts, then we can file transfer petitions in the Supreme Court and tell the Supreme Court that similar questions of law are being raised in several high courts, which may result in contradictory judgments. So you please transfer everything to the high court so that there's uniformity. Sometimes such a request is, permitted. Sometimes it's rejected because very often the Supreme Court says Well, let the high courts decide it one way or the other, and thereafter you can bring it up to us, so that the Supreme Court would have had the benefit of the reasoning and the knowledge and the cumulative knowledge of all the judges of the various high courts. So you do have instances where two high courts will have a similar view, two other high courts will have a different view. But when we come to the Supreme Court, the apex court would have the advantage of reading the judgments of the various high court, which has already gone through some extensive reasoning. Suresh, take this one.
Hey.
So yeah. Now,
Bhima.
yeah, so this is broadly the role of the judiciary, interpreting and applying the law. So ultimately, while whatever the law that is enacted, what prevails is how a particular provision is interpreted by the courts. So you have seen that in respect of the various constitutional provisions, where constantly a particular provision, meaning of Article 21 is being expanded, how it is sometimes changed, it is watered down, it is read down, it is expanded beyond the mere letter. So all this is possible, and that is the exclusive domain of the judiciary to interpret and apply the law. Then, of course, you have adjudicating the disputes between citizens. So this is where essentially the subordinate judiciary is concerned, the civil courts, in respect of property disputes, either within families or within relatives or within neighbors, whatever might be these kind of disputes, they are all settled by the courts, which will be the subordinate judiciary. Disputes between states. I'm sure all of you have been are familiar with the river water disputes between states. So now you have the GST, the fact that the center is not giving enough funds to the state governments. So you have disputes between the two states and disputes between state and the center. This is the jurisdiction to deal with such disputes is obviously with the Supreme Court. Then protecting the fundamental rights of citizens. And of course, the non-citizens also, wherever the rights are applicable. So in respect of the fundamental rights, while yes, fundamental rights would inform decision making in all courts, but for exclusively asserting your fundamental rights, the Constitution has given us, which we'll see now, the right to approach the Supreme Court directly under Article 32 and the High Courts under Article 226 of the Constitution. Then maintaining the rule of law and ensuring government's function according to law. So this is a very, very important role of the judiciary, which is to ensure that the governments of the day, the executive of the day, functions within the four corners of the wall, of the law. So if there is an executive action or if there is a legislation which is actually violating any constitutional principles, then it is the courts which will decide whether such laws can be permitted, whether such acts can be sustained or they should be struck down. So this is a very, very important, so that, and even arbitrary decisions of the governments. For instance, we have had like even your 2G scam, where the people had come to court to say that there was nepotism in the awarding of these contracts. So the courts can, because nepotism is actually a violation of Article 14. So courts do intervene to say that, yeah, the rule of law alone will prevail. And so if there are some conditions for application, for allotting of any contracts and tenders, then it is the law alone which should prevail and not the preferences of any particular government in power at that point in time. And then safeguarding the supremacy of the Constitution and ensuring that authorities function within the constitutional framework. So similarly, it is the courts are also looking to see that all other constitutional authorities, we have looked at the Election Commission, we have seen the Comptroller and Auditor General, though it's not very often that we come across such situations, and the courts itself. It is for the Supreme Court and the other high courts to ensure that each authority is functioning within the constitutional framework. Now, what are the... Yes, the courts can enforce compliance, but it depends. If it is a statutory requirement, then definitely the courts can enforce compliance, or if there is even an executive order which has a force of law, the courts can dictate, enforce compliance. Next slide. Then the appointment of Supreme Court and High Court judges. So if you look at the Constitution, the provisions in terms of the qualifications required is very sketchy. So as far as the Supreme Court judge is concerned, any High Court judge who has 5 years experience can be made a Supreme Court judge. Any lawyer who has 10 years experience can become both a High Court judge or a Supreme Court judge. And for a subordinate judiciary, it is 7 years. Right. And apart from that, you also have the direct recruitment process, which is done by the Public Service Commission, where they conduct exams and enter the judicial service. Similarly, for the lower judiciary. So it is this very sketchy kind of appointment process and the qualification process, which actually has been coming out for criticism, because it really depends upon, I mean, the High Court today, it is a collegium system. I don't know how many of you are familiar with it. In the last, I think from the early 90s onwards, 93 onwards, the Supreme Court has interpreted the Constitution. Until then, it has been the executive which would appoint judges, but they would consult the judiciary. Then subsequently, the Supreme Court said mere consultation is not enough. You will need to get the concurrence of the judiciary. Then from there, the provisions have been interpreted to say, sorry, it is not at all the role of the executive. It is the judiciary alone which will appoint, judges. And there is a primacy of opinion, I mean, given to the opinion of the Chief Justice. So the Chief Justice of India is the final word on all these things, and the senior judges, which is today referred to as the collegium, and they are the final decision makers as far as who should be appointed as a High Court or a Supreme Court judge. So, I mean, there's been a lot of criticism over this, but yeah, that's a different debate for another day. Yeah. Now, this is the main provision of the Constitution, which is of importance as far as the Indian Constitution is concerned, because I think it's one of the rare constitutions where it gives the right to the citizen to directly approach the highest court of the land, which is the Supreme Court, for enforcement and for any violation of your fundamental rights. And the Supreme Court has the power to issue writs. I mean, writs are actually what has evolved in the UK courts, the kings and the queens. But I mean, we have adopted the same language. What are each of these writs will come later. But writs are essentially directions which the courts can give. And the habeas corpus, mandamus, prohibition, quo warranto, and certiorari are generally different orders given in different contexts. We'll elaborate it a little later. But what is very important is that while if supposing a policeman, if there is custodial torture, you can in fact go directly to the Supreme Court if you want. Though you also have the right to approach the high courts. So one would definitely advise everyone to approach the high courts first, because one, it is closer home, and two, as against the order of the High Court, you still have an appeal, or the language, if it's not exactly appeal, what we call a special leave petition to the Supreme Court. So which means you have two tiers of judicial interpretation, and have an advantage to go to take up the main issue again, to re-agitate the issue before a higher court. So, but while it is advisable in practice to approach the lower courts first, the law itself does not place any impediment to directly approach the Supreme Court in situations where there may be situations like where you feel that the local high courts or the situation in a particular state is not conducive enough for you to approach the High Court, and you would rather go to the Supreme Court. So those kind of exceptions have been entertained, and it is open. But there have also been instances where the Supreme Court said, while yes, we do have the power, but you kindly go back to your High Court and then you can come back to us. Yeah, the next slide. Yeah, the right guaranteed by this article shall not be suspended except as otherwise provided for by the Constitution. Yeah, and in emergency, even this right was suspended. But yeah, this is a right which is seen as, I mean, brought in by Ambedkar at that point, saying that this is the constitutional remedy is the most valued provision in the Indian Constitution. Next. Yeah, these are the different writs which are, so habeas corpus is essentially what the slide says, produce somebody dead or alive. I mean, this dead or alive is, what was used earlier in England. But essentially, it is a direction to produce a person who is believed to be held in illegal custody. So the illegal custody can be by the police, or it could even be by a private individual. So in such situations, the courts can, exercise their constitutional powers and give a direction to the police saying that we apprehend that somebody is being held against their will in some place. So find out and bring them and produce them in court, so that the court can ascertain for itself whether the person is actually being kept in illegal detention. Then second is the remedy of the writ of mandamus. This is the most common and the most prevalent writ. Mandamus is nothing but a direction that to do or not to do something. So this mandamus can be issued by the high courts to any public authority, any arm of the government. It can be a public sector. It can, I mean, all these writs can also be issued to private bodies, though the courts by and large have, it is a self-imposed restriction on the courts to say that, well, we will not, if you have an alternative remedy, for instance, if you can go to a court in the subordinate judiciary, or if you can go to the labor court for a particular purpose, if you can go to the NGT to get your relief, in such situations, we will not, exercise our power, because you do have an effective alternative remedy. So you exercise that alternative remedy. If you are aggrieved by that, yes, then you can always come to the High Court. So courts have imposed certain kind of a self-imposed restrictions and limitations on their power, not as a legal impediment or a lack of authority, but more as a way to regulate things so that the courts don't get clogged. Then a writ of prohibition, as the word itself says, it can, even before a particular act is taken, is done, the courts can issue an order to any authority to say you stop from exercising a particular or proceeding in a particular manner or in a particular direction. Then the writ of quo warranto, this is essentially when we believe that somebody who is occupying a position, it does not have the qualifications to occupy. For instance, supposing a high court judge is a person who does not have the 10 years qualification. A lawyer with just 5 years practice has become a high court judge and has been sworn in. At that point, any citizen can actually go to the high court and file a writ of quo warranto to say under what authority is this person sitting as a high court judge. And it has happened. It's not as if writs of quo warranto have not been issued against high court judges. They have been issued, or even against anybody. For instance, all authorities. Any person who is holding a public office, a writ of quo warranto can be issued. But what is necessary to show that is that they do not have, see, the person may not be the best person. You may have a difference of opinion. You may feel that, this person is not fit to hold that office. But it is not, people are not going into the merits of a person. What the quo warranto is writ is only limited to examining if the person concerned, fulfills the basic qualification which is set by law. And the writ of certiorari. Certiorari is actually expunging or removing an order which the court holds to be illegal. So supposing the government issues a government order, which somebody challenges it, saying that this order is in violation of the constitutional principles, or it is in violation of some other statute, whatever it might be. And once the court holds that a particular law, a particular government order or an act is bad, essentially it is these are orders, the court can issue what is called a writ of certiorari, which means it quashes that order. And the effect of such a quashing, so such a writ of certiorari, is that it is effaced from the books altogether. So it is almost like you are brought back to a situation when such an order did not exist at all. So that is what a writ of certiorari is. A court can also, it is not like a court can issue only one writ at a time. The court can exercise the writ of certiorari and then further issue mandamus. So in Tamil, in Madras High Court, it is very common for us to ask for a certiorarified mandamus. So certiorari to quash something, and you may not be satisfied. You may not get a complete relief by just quashing the order or setting aside the order. You may want the court to issue further directions. So which will be a mandamus. So even such combination of writs is also possible. Yes, in the next slide. Yeah, Article 226 is the power of the High Courts. So if you look at the opening sentence of Article 226, it says, notwithstanding anything, Article 32, every High Court shall have the powers. So why that notwithstanding? That yes, you have the right to go to the High Court, to the Supreme Court under 32 for violation of the for your fundamental rights, but merely because the Supreme Court has been given the power, it does not mean that the High Courts are denuded of that power. So they say, okay, Article 32 is there, but nevertheless, for the same kind of relief, you can also come to the High Court. And if you see the jurisdiction of the High Courts, if you see, they can issue, of course, throughout the territories in relation to which it is exercised. And the first clause says the same thing. What are the nature of the writs that they can issue? Now, just pay attention to the last sentence of the first clause. So, including writs in the nature of habeas corpus, mandamus, prohibitions, quo warranto, and certiorari, or any of them, for the enforcement of any of the rights conferred by Part 3. Part 3 is the fundamental rights, and for any other purpose. So, the words for any other purpose, you can see how broadly it has been worded. So, in many ways, the powers of the Supreme Court under Article 32 are actually restricted because it is only for violation of your fundamental rights. But whereas the powers of the High Court under 226 are much wider because it is not only for violation of your fundamental rights, but for any other purpose. So when you are, debating, oh, let's go to the Supreme Court because it sounds very fancy, please keep in mind that very often it is the High Courts which actually enjoy greater powers than the Supreme Court under 32. Of course, there are other articles in the Constitution where the Supreme Court has omnibus kind of powers, but as a court of origin, that is, if you want to file your petition for the first time, it would actually make sense to approach the High Courts under 226 because the powers are very wide and very vast. Yes, Sayantan, it may not be the necessary. No, this, I don't think you need to go into all these details. Yeah. So just to conclude, so the power of the Supreme Court under 32 and High Court under 226 is to issue these 5 writs and also beyond. So you're not, constrained by these 5 writs to any person, authority, or government. But while any person is again very broadly worded, as I mentioned to you, if you have alternative remedies, generally courts will ask you to approach the other courts before they will come to the High Court. Even if only part of the cause of action occurs in the territory under its jurisdiction, the High Court can exercise powers. For instance, supposing a factory which is, partially located in Tamil Nadu or partially located in Andhra Pradesh, or a person who has done something in Tamil Nadu has then moved to the Andhra Pradesh. No, so which is what we call a cause of action. Cause of action is what is the reason or the cause for which you want to go to court. So sometimes, a action can emanate in one place and conclude in a different place. So even if a part of the cause of action occurs, the High Court will have jurisdiction. So even merely because somebody committed an offense in Tamil Nadu, then the same, and then has gone to Andhra and then gone to Karnataka, and a portion of the scam money has gone to Karnataka. Whatever it might be, these transactions, there are multiple transactions. Any of these High Courts can actually have the jurisdiction to take up these issues because a part of the cause of action has occurred in that territory. And the power of the High Court cannot affect the power of the Supreme Court under Article 32. That, of course, the Supreme Court is a superior court. And so, yes, while the High Courts have wide power, Supreme Court equally has powers under 32. Yes. So, broadly, this is how we kind of categorize it. Appellate, see, original jurisdiction and appellate jurisdiction. See, that the difference is the court in which you can initiate a process is called a court of original jurisdiction. And from the court order, you can go to if you have an appeal remedy, that is called an appellate jurisdiction. So there are, like, for instance, a district court, in certain instances can be the court of original jurisdiction. In certain instances, it will become an appellate court. Similarly, the High Court. The High Court will entertain appeals from the civil court, but there are also disputes on the original side where you can file a case directly in the High Court. So that is why the original jurisdiction and the appellate jurisdiction. Review. Sometimes the courts may pass an order. You have a right of appeal, but before exercising the right of appeal, if you say, like, on the face of it, the court has made a very glaring mistake, a glaring error. Like, for instance, a particular provision of law was not brought to the attention of the court, or a particular event has not been brought to the attention of the court. So instead of exercising the appeal remedy, you can approach the very same court and file what we call a review petition and tell the court, see, there is an error which is staring in your face. What we call, the language of the courts is apparent on the face of the record. So you don't need to go very deep into it and look into the facts in great detail. On the face of it, there is an error. And in such situations, you can file a review petition. And there have been very many instances where courts have reviewed their own order and have recalled the previous order and said, yes, we have been wrong. This particular provision of law was not brought to our notice, or this particular fact has not been brought to our notice, and have recalled their earlier orders and revised their opinions. Of course, after the review order, whatever may be the thing, an appeal remedy is always available to you. And chartered high courts, Bombay, Calcutta, and Madras. Charter is the Queen's Charter. We still function under that. So the colonial hangover still exists. And so these chartered high courts have what we call the original jurisdiction, where you can institute a suit. You can file a suit in the high court itself. Other high courts don't have that jurisdiction. Contempt jurisdiction. If there is a violation of the order of the court, courts can haul up the executive or any person to say that, why is it that you have not implemented my order? Or if they in any way, bring down the reputation of the court, also courts can interfere in and exercise the contempt jurisdiction. Then in addition to that, Supreme Court has what is called an advisory jurisdiction. So advisory jurisdiction is where the President of India can actually, in a very important question, the President can refer to the Supreme Court saying that I need advice on such a matter, you please, and refer it to the Supreme Court. And the Supreme Court can then exercise its advisory jurisdiction and lay down the law and says, yes, this is a process by which, a particular action should be taken. And then the power to decide intergovernmental disputes, which I have already said, disputes between states and center, two or multiple states and the center and the state. Then this is what is the special leave petitions. Special leave is not a regular remedy. It is not a regular appeal as a matter of right. But if you can always seek special leave from the court, as the word suggests. You're seeking the leave of the court, that is a permission of the court to say, well, there is an order of the High Court by which I am aggrieved. I'm not happy with the order of the High Court. The High Court has made certain mistakes, and I think the law laid down by the High Court is wrong. So I seek the permission of the Supreme Court to move an appeal before you. So because it's not an automatic right of appeal, only if the court gives you permission, you can actually access that appeal remedy. Yes. Fine. So from here, we move on to the public interest litigation. And Suresh will now take you through the PIL.
Any questions so far? It is a very rapid trip around the whole judicial system. see, it's very easy to understand it. You have the nation at the top and therefore Supreme Court at the head of the, so you have Parliament, which is legislative authority at the highest level. And then you have the Prime Minister there. The equivalent here is Supreme Court and the Chief Justice of India and the other Supreme Court judges. Then under the nation, you have the states. So in each state, it's a High Court, which is the top of the legal hierarchy. Then each state is divided into districts. Districts are divided into talukas. Okay, so the state has the highest court is the High Court. The talukas are the districts. The highest court there is the district and sessions court, both civil jurisdiction and criminal jurisdiction. Then under the district, you have the talukas. So the talukas have what is called the magistrates courts and the district municip courts. So the magistrate courts are the criminal courts, municip courts are the civil courts. The names may vary from district to from state to state, but broadly that's the structure of the courts. Okay, so this is this is how you would understand the regular structure. And then as time grew, as time went, and complex transactions went, they came up with other courts to handle a wide variety of issues that were not conceived of in earlier times. So that's how the tribunals came, then the other courts came. I'll just stop here. Can we just have a couple of responses? Did you understand it? Is it making sense to you all at all? Before we get into PILs.
Yeah, I have a question. So what is the distinction between like a civil court and criminal court? And how do we know, yeah, I guess like which matters would go to either court?
Okay, can any of the other colleagues listening to this take a try? What's the difference between criminal court and civil court? Let me put it this way. What's the difference between criminal law and civil law? A civil dispute or a criminal dispute? Would somebody like to make it to try out? Hey, it's not so difficult that you can't.
Yeah, criminal courts deal with the cases which come under Criminal Procedure Code.
Okay.
And
So what does that mean?
The crimes of that sort of crimes which are listed under CRPC, like murder. Am I sounding very?
No, you're sounding right. You're right. You're sounding very right.
Okay. And I think civil courts deal with like issues related to land,
Property.
non-criminal, yeah, property, land.
Or that which is not criminal.
Yeah, that which is not listed under crime.
Okay. Okay, I think it's a fairly good one. Good, very commonsensical understanding, which is actually that. See, you please keep in mind, law is nothing else but common sense. Of course, then every profession has to make their profession sound like very learned. So they have a lot of these Latin terms and other terms you don't understand. But the basis of it is that it's a very commonsensical thing. So a criminal would be an action which inflicts an injury on somebody else. Okay. Now the injury could be physical, like I'm hit and there's blood coming, or there's a tear, or there's a fracture, or any of those things. Injury could also be personal in the sense that there's no physical injury, but there's injury of my reputation. So that is defamation. Okay. Though there is something called civil defamation and criminal defamation. So criminal acts mean any action which affects somebody else, which has been declared by law to be an offense. Okay, that is a criminal action, criminal offense. Now it means what? If that act has not been defined to be an offense under the law, then it is not a criminal offense. For example, for a parent to beat a child or to harm the child through various means can be brought under the criminal law. But there is no law which says that the parent has to necessarily feed the child properly or feed the child nutritionally. nutritionally rich food. There's no law to say that. Okay. But there is a law to say that if a person beats up somebody else causing harm, that is a criminal act. And that will also apply to parent and a child relationship. It's not used. People don't look at it as a serious thing. That's a different matter. But in law, that's how it is done. But there is no law which says that you have to take care of your servant, the house servant, in a proper way. That's not defined as an offense. Okay. So an action is criminal in nature if it inflicts injury, and that action has been defined in law to be a crime. Then it's a criminal action. That criminal action will be you will have to pursue it in the criminal court, either if you are a complainant, or if you are the accused, or you are a victim or a witness. There are three parts. Anything else which is not criminal, broadly, again very generalistically saying, would be civil. That is, any dispute between people over property, over land, over any of these other things, including inheritance, is civil law.
Yeah. See, for example, let us take something which is very simple. Supposing you have borrowed money from somebody and that person has not returned the money to you. It is a civil dispute. You have a business negotiation. You have entered into a contract with a supplier, and the supplier has promised to supply certain material to you by a particular date, and the supplier has not, kept up that promise, or has sent you inferior quality material. Now, all these are civil disputes. But supposing there is cheating, like for instance, your, now the whole cyber security, people are calling up, they cheat you of your money. Then that's an offense, because cheating is an offense. So this is broadly to give you an idea. I mean, there can be situations where a particular transaction can attract both the civil law and the criminal law.
Like check bouncing cases.
Or even an act of somebody has cheated you out of, some money, some 10 lakhs or property or whatever. If you can prove that, there is an element of criminality, because that is an intention, that actually this person approached me not with the intention of having a particular, civil contract or a civil transaction with me. He approached me right from the beginning with the intention to actually take me for a ride. He came forward with this offer only so as to cheat me. So if you can actually bring in some evidence to show that there was an intention to cheat you, and thereby he cheated you and has, taken your money, you can file a criminal case for cheating against that person, and in a criminal court will then prosecute him and punish him for that. But he may be punished and be sent to jail, but you're not going to get back your money. So if you want your money back, then you go to the civil court and file a suit for recovering the money from him. So the same act of cheating you of 10 lakh rupees can be both a civil and a criminal proceedings can be initiated. So I think that should suffice for now.
There is one question by Sham. Aren't these provisions empowering citizens rendered ineffective by the fact that courts can choose whether to take up a case or not and decide a case's timeline? I think this is with respect to the SLP that you had mentioned. He also asks, if yes, is there any way citizens can compel a court to take up an issue?
See, the basic fundamental thing is that court should have the jurisdiction to try your case. So you will have to show, now jurisdiction is in 2-3 things. One is jurisdiction, which is geographical, that you are living in the area in which a particular court is situated, and therefore that court should take it. The second part of the jurisdiction is whether that subject matter on which you are wanting to get a remedy is provided in the law, and whether that court is authorized to deal with it. That is also a jurisdiction issue. Okay. So if you are able to show all of these things in your petition, then you can as well tell the court, look, this is the reason I've come here. You have the jurisdiction to do it, both under law as also by geography, and therefore you should take it up. And if the court refuses or rejects to do it, you always have what is called appellate remedy. You can go to the next higher court and say, this court has jurisdiction, but it deliberately did not want to exercise that jurisdiction. Okay, so you have a remedy to take it up to the higher court. If the higher court accepts what you're saying, it will send it back to the lower court for the lower court to try it out.
And of course, the timeline is something which is very difficult in our country, considering the backlog and the the case load in the cases in our courts.
And also
So-
the shortage of judges. We have one of the most abysmal records in terms of the population to judges ratios. Okay, and it's very, very vast. So there's no way it's going to meet. We also have very massive infrastructure problems in terms of number of courts, number of stenographers. I mean, sometimes it's very humorous. You'll have a stenographer, but no typing machine or no computer. You may have a computer, but there's no printer. You may have a printer, but there's no budget for paper. So people working in some of the lower courts, I mean, the lower court staff will tell you, please get this, please get that to do their work.
How many of you have gone to a police station to give a complaint and the police fellow will ask you to buy a paper and bring it? That happens very often. They'll ask you to buy a sheaf of papers to write the complaint. So yeah, so that is all
Okay,
part of the way
that's the way it is. But that doesn't, that shouldn't come in the way of recognizing that there is a hierarchy of courts and the courts are functioning not too badly. We can complain. There are lots of complaints, of course, of delay and all this stuff. But the system has been tested and has been proving to function fairly decently. There's scope for 100% improvement, but it's not bad. You look at other countries in our area, and then you look at our courts, it's not too bad. Okay, we're not defending the judicial system because we are lawyers, but it could be still worse. Anything else? Can we go on to the... no, we will take it up later. Okay, so see now in one of the most important things that was discussed during the Constituent Assembly is to say, okay, you've given people fundamental rights. You have recognized that they have certain rights which are fundamental to their existence. We consider all those rights. Now, merely giving them rights, is it sufficient? If the rights are violated, where do people go to? So that is how the discussion came on about constitutional remedies. That giving the rights itself was a very major departure from, remember, we had spent a lot of time 47 to 49. Many of these rights did not exist in that period. We did not have universal suffrage at that time, meaning election rights. We had election rights linked to property, linked to whether you're a graduate or not, linked to caste, linked to class and other things. So the first thing is to, one, recognize rights. Second, recognize that some rights are more fundamental than the others. So fundamental rights were given. And then they said, if fundamental rights are violated, therefore, without giving a remedy, it becomes useless. That is how the constitution makers provided for Article 32, which Saila had covered. Okay, we'll now look into that a little more. Now, Article 32 is to be exercised in the Supreme Court. It's a right of a citizen or any person in India living within the territory of India to be able to go to the Supreme Court directly, bypassing the entire hierarchy of courts. There was a lot of debate in the Constituent Assembly as to whether this right should be there. Should they not go at the lowest level like in the British system and then keep going up? They said no. In a country which is trying to change centuries of discrimination and inequity, you need to have a process by which people should be able to go to the highest court of the land to get justice. Okay, so that is how Article 32 came. Then, for those who do not want to go to Article 32 is part of Part 3 of the Constitution, and therefore Article 32 itself is a fundamental right. So this is the beauty of the fundamental right. You have a fundamental right to a constitutional remedy for violation of other fundamental rights. Okay. Now, that is with regard to the Supreme Court. The constitution makers also then asked the question, what happens at levels below the Supreme Court? We had a system called the federal court before independence. Okay, so the federal courts became the Supreme Court. So that is how, after that, when they came up to the high courts, then they said in the high courts, insofar as the high courts are concerned, there should be a separate right, and that right was Article 226. Now, Article 226 is not a fundamental right, It is what is called a constitutional right. So for constitutional right is very broad. Article 32 is only violation of fundamental rights. But Article 226 is a violation of all other rights, and it's also remedies for the citizen. So Article 226 is a much wider thing. It's like a big wider thing, and a smaller one is Article 32. Okay, it's very important to understand that. Now, in all of these things, for the first say 25 years of the Constitution, things were going on as normal litigation goes. Now you all know that in litigation there is a party A and a party B. A and B have a fight with each other. Okay. So A goes to the court saying that B did this or did that, or he cheated him, or took away his money, or grabbed the property. Okay, whatever else it could be. So they were adversaries with against each other. You went to the court, and the court was the what is called the neutral arbiter. Arbiter means the person who is arbitrating between two people. So the court was the neutral arbiter. And this proceeding was called an adversarial proceeding. Okay. So the person who went to the court to file the case, like Sham had asked earlier, how do you go? You go to the court and say, look, I have a locus. Locus means I have a reason to come to this court because of XYZ legal violation that has taken place. And the only remedy is in this court, so I'm coming. Okay. I am therefore the aggrieved person. I am the person who wants an amend to what has happened, or I want a relief for the suffering that I've undergone. Okay, so that the legal term is you are an aggrieved person and you are going to the court. Now this is called locus standi. Do you have the locus standi to go to the court or not? Which means, do you have the right to approach the court? Are you an aggrieved person? Okay, is there a solution that you have in the context of law? Okay, so until 1973-74, all courts interpreted both Article 32 and Article 226 to say only if there's a person who's affected by something, they can approach the court, Supreme Court by way of Article 32, or the High Courts by way of Article 226. Now, around the same time as emergency, lot of issues started taking place. And many people started writing to the Supreme Court complaining of very serious violations of their rights. Okay. And there were also people who wrote to the court who themselves were not affected parties, but they wrote on behalf of other people who are victims. Now, in a country like India, there's possibility that many victims are there who will not be able to come out publicly and talk about their problems, because they risk being killed, they risk being tortured, they risk being the properties being taken away, being thrown out of the houses, and huge things. So there was a situation where increasingly many of these problems started becoming major. Affected victims could not come. Okay. And the courts were held to think about what do we do with this type of complaints that are coming up. Now, we had, I will show you in the next few slides, the entire change in the way the High Courts and the Supreme Courts approach this problem. In the 70s, you had people like Krishna Iyer, you had people like, Chinnappa Reddy, Justice Krishna Iyer, Justice Chinnappa Reddy, Justice D.A. Desai, Justice Bhagwati, and various others, who had a very progressive understanding of both the law and issues. So they said the time old, which is the British system of locus standi, should need to be opened up. It should not be left only to a person who is an aggrieved person or a victim to come to court. Anybody who brings to the court, to the attention of the court, the problems faced by some other section of people who cannot talk, that case should also be taken up. It started coming up with a set of the many things that happened. I'm just giving you one or two just as an example. Some prisoners from Tihar Central Jail wrote a letter to the Supreme Court saying, this is the type of torture that has happened here. This is the type of treatment that has been given to some people who raised questions vis-a-vis the prison administration. They were beaten up. They were kept in solitary confinement. This is going on. Kindly intervene. The Supreme Court then said, okay, now what do we do? The fact is that it has now been brought to their attention. The Supreme Court normally before the 70s would say nothing to be done. The affected person come, we can't do anything. But by the mid-70s, the judges started saying, no, we cannot take that very mechanical, very official approach. We need to do something about it. So what they did is, instead of waiting for a petitioner to come to the court, they said, we will treat the letter from these people itself as a petition, and they started looking into those cases. Okay, so the first important breakthrough there, the legal breakthrough, was the fact the Supreme Court said, you don't need to have a locus standi to come to the court for violation of your fundamental rights. If you're able to show violation of your rights or your fundamental rights, you do not. What you needed to show was that people are coming to the court in public interest. So it is not Suresh filing a case through somebody else for the benefit of Suresh. So Suresh will be fighting this case on behalf of, say, the fishing community of Chennai, who are being affected by a particular road. Or Suresh will be filing a case in terms of any other sections of people. But it should not be for private interest. It should be for public interest. Okay. So the Supreme Court then said, if it is therefore in public interest, then it should not be looked as an adversarial litigation. Okay. It's not X claiming against Y. It is the petitioner in the PIL bringing to the attention of the court why the court should intervene. Okay. And it is not against Y, but it is claiming relief under the Constitution on behalf of some people. Now, obviously, the relief is vis-a-vis the state and the state government. And the court said, told the state, you can't look at this as an adversarial litigation and try to attack the person who's filing these PILs. Shall we go to the next slide? It will become a little more clearer to you. So, like I said, this is the letters which went in earlier. Then there were newspaper reports. For example, there was a place called Bhagalpur in Bihar. The prisoners there in the Bhagalpur jail were protesting against inhuman conditions there. Food was not there, water was not there. What the policemen did is that they pierced the eyes and put acid into the eyes. Okay. Now, I don't know how many of you are, you have heard about this. It's called the famous Bhagalpur blinding case. Newspaper reports talked about how prisoners were blinded, one by the needle piercing the eyes, and second, by acid being put into the eyes. You can imagine what type of trauma those people would have gone to. By the time this came out itself, it was quite a long time. And obviously, the policemen are not going to give them any medical remedy. This was read by the Supreme Court judges and said, this was a horrifying situation. In a land where the Constitution is providing these remedies, Article 21, right to life, exists. And if we do not exercise the right of Article 21 vis-a-vis the affected prisoners, we are failing in our duty as Supreme Court and as Supreme Court judges. And they took it up on their own. Then the facts which are brought by third parties. For example, there was a person called Olga Tellis, a very famous journalist in Bombay, who wrote to the Supreme Court and had also written, she's a journalist, so she wrote about it, how in Bombay, in the mid to late 70s, the municipal corporation, they waited till the monsoons. You know, monsoons are extremely heavy in Bombay. During the height of the monsoons, they went about demolishing the slums and areas where the poor were staying in, what they call the Juggi Jhopadis, so that this land can be given over to real estate people. Okay, so it was such people, journalists, writers, academicians, activists came a little later, but at that particular point in time, other people with a public spirit. Okay, this is one type of thing where, when it was brought to the attention of the Supreme Court took notice of it. There were other things, other cases. Supreme Court itself, so motu, which means on its own motion, they took notice of the migrant, for example, on migrant workers, and a whole lot of other issues. In fact, there's one case that came up recently. We can come to that towards the end of it. How the Supreme Court, how the Madras High Court so motu took up a particular case, but we'll come back to that later. So there were two types of things. So when people wrote, or affected people wrote, or journalists and others wrote, the Supreme Court took notice. And sometimes the court took notice of itself on its own. There are instances of a judge who is going in a particular area. He sees an absolutely deplorable condition. He comes back and takes it up as a PIL. So the 70s and the 80s, you had a lot of things. Now, the point to be kept in mind are two things. One, locus, and two, it should be in public interest. It should not be to favor any particular person or particular group. It should also not be political in nature. Now, as we shall see in the next one, these are called the epistolary. Epistle means a letter. It was called in the early 70s, it was called the epistolary jurisdiction or the epistolary cases of the PILs. A large number of cases were filed at that time. Okay. Now let's see what are the early PILs. The early PILs in the 70s and the 80s were of the most poverty-stricken, the marginalized, the weakest, the voiceless social sections. Okay. For example, at that time, the issues of under trial prisoners, women prisoners, under trial prisoners, convict prisoners, okay, people who have spent 3 to 10 years in jail without trial even starting, those issues went in. Then there were prisoners' rights, for example, solitary confinement. Sunil Batra, Sunil Batra was a big time criminal who was convicted in major cases. He wrote to the Supreme Court a letter talking about the prevalent practice of solitary confinement and how solitary confinement was used as a punishment by the prison authorities. Okay, Supreme Court took it up. Now, as you will see, the period, this is the period of the 70s and the 80s. The judges were a lot more progressive. Judges were also understanding that behind the so-called development, there's a huge failure. And that this development is not exactly development, but there's a destructive element in that development. So in that initial period of 10 years, the harshest part of life in India went up to the Supreme Court. Okay. So like there's a very famous writer called Usha Ramanathan. She writes about how the early PILs involve the civil liberties of people, the disenfranchised, the dispossessed, and the rightless. People who only in law they were given right, but they actually experienced no law. So this was the early period in the 70s and the 80s. Sainthan, I think you should make it a little smaller so that you can see it on the top. Okay. Can you go to the next one? Yeah. Can you go to the next one? Okay. Then by the mid 80s, the early 80s to the mid 80s, okay, the type of issues that were taken to the Supreme Court and to the High Courts. Now, please keep in mind, it is not just Supreme Court. People also approach the High Courts using Article 226 on public issues. Okay. For example, migrant workers, Bandhava Mukti Morcha case is a very famous case in 1984. Olga Tellis, I already talked about. Children and child adoption case. Okay. The plight of mentally ill persons. So Professor Upendra Bakshi had filed, I think one of the papers circulated was Upendra Bakshi's social action litigation, SAL, he would call it, or what came to be also called as public interest litigation. So the initial period was marginalized peoples, absolutely rock bottom, very, very major levels of immiseration, exploitation, etc. By the early 80s, things started changing. Once people realized that you can actually go to court and the courts are responding with some measure of humaneness, some measure of dignity, some measure of recognizing that people need safeguarding, then the social issues started being taken up to the Supreme Court. As we shall see in the next slide, okay, comes the 1990s. Okay, now this is the liberalization period. Okay, so from marginalized and the weakest in the 70s, mid 70s to the mid 80s, to the social issues of bonded labor. In particular, bonded labor was a very major issue that went up. Minimum wages issue went up. A lot of such issues of social character affecting a large class of people. In the 90s, when also coincided with the liberalization period, 1991, as you all know, is a period of globalization, liberalization, and privatization. Okay, the issues that went up to the court started changing. Okay, the changing now was no longer talking about the most marginalized, etc. They now started talking about other issues. Okay, issues now of democratic life, issues of governance. Okay, no longer issues of utter poverty. So you had issues, for example, of air pollution, water pollution, and environmental protection, which started going in the 90s. Okay. For example, corruption issues, the Hawala case in the 90s. Many of you are too young to remember that the Hawala case, Vineet Narayan took it up in the Supreme Court. The Fodder case, okay, the Fodder case is the one in which Lalu Prasad Yadav has been convicted. He's still suffering the conviction of the Fodder case. 1993 to 97 was when that took place. He's still facing a lot of cases. There's still a couple of criminal trials in which judgments are yet to be delivered. Okay, but corruption now started coming to the public eye, it also started being taken to the Supreme Court. You will see between the Hawala case and the fodder scams case in the 90s, and then you take up the present case a couple of years back of the Rafale, and how did the Supreme Court deal with it? There you will see the changing character of the Supreme Court. Okay, but so anyway, at this point in time, then in the 90s, you had air pollution, water pollution, problems of mining, cleaning up the Taj, and other issues, which are more linked to the directive principles of state policy, which we had already seen. So many of these issues, eventually, for example, right to education, was taken up as a public interest litigation, which is basically giving teeth to the fundamental, the directive principles of state policy vis-a-vis education. Shall we go to the next one? Yeah. Okay. So again, continuing the 1990s, it goes up to the mid 2000. Okay. So disposal of hazardous waste, sale of pesticides. These are all big cases at that time. They were emerging cases at that time, and they were taken up to the Supreme Court. At that time, the corporate bodies were at the receiving end of a lot of this. By the late 90s to the early 2000s, the corporate sector now started hitting back, and that changes the contour of PILs. Okay. Political changes take place. That also has an impact. And I'll come in a moment to that. Okay. For example, sexual harassment at workplace, the Vishaka case, this was actually taken up by PUCL, to which many of us belong to, from Rajasthan. One of our colleagues, Kavita Srivastava, she took up this case of the Vishaka, which went up, which was a noon meal worker in a remote village in Rajasthan, who Bhanwari Devi, Bhavri Devi, her name is Bhavri Devi. She took up the case of how there's a lot of corruption in the schemes meant for the poorest of the poor in those areas. How there were ghost plants, schools which are constructed for which money was taken, no schools are there, no roads are. Huh? And like that, many issues went up. And she also took up the issue of child marriage. Okay. Now, for the fact that she took up the issue of child marriage in a Rajput area, she was raped. Okay, and taken in. And that case went up from the High Court. High Court dismissed it. She took it up to the Supreme Court. Supreme Court then gave eventually what is a very landmark ruling in terms of sexual harassment in the workplace thing. Then you had the female feticide case, regulating blood banks, and so on and so forth. Let's go to the next slide. Okay. Now, in the 21st century, the priorities which went to the Supreme Court started changing. Okay. And the response of the courts also started changing. So you had the best of liberal, progressive judges who are very sensitive to issues of poverty, discrimination, structural exploitation, etc., who are now retiring. A new set of people started getting elevated in the high courts and the Supreme Court. These people had a very different notion of issues. Okay. They did not, their approach was now a lot more saying, how do you always give in to the issues of poverty? As a nation, shouldn't we also develop? Shouldn't we also sort of have better infrastructure? Shouldn't we also have more industries so more people can get jobs, etc.? Why is it that every industry is being challenged on environmental grounds? Okay. So this issue started coming up to into the courts. Like I said a little while earlier, now the corporates are now hitting back, and they started talking the language of development versus environment. They talked about development vis-a-vis people's rights. Okay, so it is always posited as this against that. So in the PILs that went on in the Supreme Court and the High Court, this became a major issue. The biggest of these issues was, of course, the Narmada Bachao Andolan, okay, which Medha Patkar is very famous. This went to the Supreme Court on the Sardar Sarovar project. Literally, the whole of Gujarat, the civil society of Gujarat, was divided on the whole line of pro-dam versus anti-dam. In Madhya Pradesh, people were divided on pro-dam and anti-dam. Now, people in the dam areas would say, what about our rights? Because hundreds of villages were inundated with water and they were pushed out. They lost everything. Compensation never came, though they were promised, they never came. And overnight, they became landless paupers, eventually becoming beggars in the cities. Okay. The slums started burgeoning because of many of these people who were driven away because of developmental projects. Okay. In the beginning, it was developmental projects in terms of infrastructure development. Subsequently, it became developmental projects in terms of industrial development. Okay. Who went there? Okay. Rehabilitation, resettlement, they talked about, courts talked about, but they were not really particularly keen or continuing to look at it in terms of whether the project should start only after rehabilitation and resettlement takes place, or should the project come because it's necessary and we will take care of rehabilitation and resettlement later. Now, in a country like India, you know what that means. Okay. If you say you take it up later, then it will never come. But that's unfortunately the reality as of today. I have been in areas, for example, in Rourkela. Okay, Rourkela steel plant was set up in the 50s. Till now, many of the people whose villages were taken over by the project have still not been given back the land. Okay, now 2-3 generations have come. They've not got land. They've not got jobs. And they're still now living in small slum areas, in areas where they were once living in a dignified existence as proud owners of the land in those villages. Okay, so these big infrastructure, industrial development projects started coming in. And what happened is, in the courts now had to deal with people versus environment versus development. Okay, and within a moment, I'll just tell you how what happened when these three things started happening. Okay, so you had the ND Dayal case in which they talked about the environmental impact report and the negative expert committee report. Earlier, they said, if you don't have a EIA report, you can't go ahead with the project, because EIA report is required so that people know. For EIA report, you need to have public hearing. If there's no public hearing, then the EIA report is not to be accepted, and which means the environmental clearance cannot be accepted. Okay. Now, in the present government, they have changed the law to say you can start the project, and after the project is started, you can come about with the EIA, and environmental clearance can be given what is called ex post facto. That is, after the setting up of the industry, you can then go and get your licenses. And it doesn't take much common sense to understand what this means. The industrial promoter will say, I put in 500 crores to come up here, and I'm giving so much employment. Foreign exchange is coming in. If you take me out, all that is going to go waste. Now, generally, IAS officers and other bureaucrats, as also the courts, will say, oh, so you put it, okay, doesn't matter, let's adjust with what we have. Okay. So this ex post facto in India doesn't really work. But that's how, when the challenge is between people, development, and environment, the whole pendulum starts changing. Now, for example, relocation of thousands of polluting units in Delhi. Now, many of you may not know this. The massive number of units in Delhi were overnight thrown out by the Supreme Court. On the whole issue of pollution on one side, air pollution on the other side, and vis-a-vis workers' rights on the third side. Okay. Similarly, with demolition of slums and unauthorized structures. Okay. So there's a case of a person called Almitra Patel, a professor from Indian Institute of Science, who went to the court and said, the problem of, the issue, the demand of the slum dwellers and urban rights issue activists, that before you evict somebody, you give alternate settlement. Okay, it's like rewarding a pickpocket by giving him back the money and ask him to go. Now, I am not joking. This is part of judicial record. In a PIL, this is what has been recorded. So this was a dictum in the early 2000s too. Actually, it's still going on now. That if I am the owner of a particular area, or I'm staying in that area for time immemorial of multiple generations, I am thrown out. It would be basic to expect from a welfare state that I should be given alternative place to stay, and my needs should also be taken care of. People have now come forward to talk about this type of a demand is not equitable. This type of demand is not fair and just. If the state is therefore going to give it, it is like rewarding pickpockets or thieves. So the whole vision now starts becoming skewed. From looking at people in terms of poverty, inequality, discrimination, it is now whether you own that property and therefore you have right. If you don't own that property, you have no right and therefore you have no citizenship. Okay, this is how in the whole structure of things started. So when it became people versus environment, okay, environment won, like in the Delhi type of a thing. If it became environment versus development, development one. If it was people and environment versus development always one. Okay, in the courts, you see a repeated pattern from the early, say 2005, 2008 period going on till now. As the next slides will show you, these are just a small set of slides. Okay, the huge number of backlog. Okay, now there are mega scams. Okay, and mega problems. For example, the burning of stubble in Delhi. It's a mega problem. It's not a problem of Delhi. It's a problem of agriculture area in and around Delhi. Okay. Now, it is here that a number of interesting cases went up. PUCL is famous for the starvation and the food security case. Arvind, I, Saint and Saila, we're all part of PUCL. So this case is one of the most interesting cases at a global level. In 2001, Kavita was a part of PUCL Rajasthan at that time. She's now the PUCL national president. Filed a petition in the Supreme Court saying that the FCI godowns are full. Its grain stocks are full. Yet outside the FCI godowns, many children have died because of hunger. And she said, in a country like ours, which with its constitution, this is not just ugly. Okay, it is something to be constitutionally condemned. And they went to the Supreme Court, saying that every year, enough grain to feed 3 times the poor population in India is either getting rotten or eaten by rats. Okay, if this grain is given to people, okay, through sufficient work programs, okay, people don't need to either go through hunger or through malnutrition or to die. Supreme Court took that matter very seriously. Okay, and they issued a series of orders over the next. It started in 2001. It ended in 2016, when finally they closed the case after the passage of the Protection of Food Security Act in 2013. Okay, and then subsequently it was changed in 2016. Okay, so that came up from the PUCL case, starvation case. Then the mining crisis came, the coal scam, the bauxite scam in Goa, in Orissa, in Madhya Pradesh, in Gujarat, in Karnataka. All these big scam cases came and went there. Okay, then you had the 2G scam, the PIL series, Subramanian Swamy and others. These are the mega scams. Now this is no longer talking about lack of development. No longer talking about problems of people at that local level. You're talking about big things. These big cases, PILs went to the Supreme Court. And the big PILs obviously involve big-time corporate interests. Big-time corporate interest means big-time lawyers. Big-time lawyers means bulk of the time of the court is now going into these cases. Okay, but it's also a fact that it's not as though they are not important. They are important, and they are in a very, very big-time case. Now here, I would just like to share with you all, I was appointed by Madras High Court as amicus curiae, meaning to help the court in a mining scam case in 2016. Okay, that case, the judgment was given day before yesterday. Okay, and after 9 years of my working on this case, filing about 4 big reports, 2 or 3 smaller summaries of those reports, okay, gave a report which the High Court has accepted completely. And I talked about a mining scam of such unimaginable proportion that it could not have been possible for the scam to take place without the involvement of officials from the highest level to the lowest level. Now, since I was an activist, I've been in PILs for a long time. Saila, I and the PIL in PUCL, we've been working on this for a long time. So I went to court and said, please ask for investigation from the highest to the lowest. Unlike normally where you start from the Tahsildar, you start from the constable, SI, and by the time you go up, people forget it. So the High Court was accepted the reports, talking about the scale of the what is called the beach sand mineral mining. It's a small sliver of land in the 3 southern districts of Tamil Nadu. Okay, and it was again one of those mega scams, very, very big time. So you also have therefore the big time lawyers coming in, and the big time lawyers, then fighting for the various mining companies. It was a very, very difficult type of a challenging thing. It is a fluke of the 1 in 100 cases you win, and that happened to be the case that was decided day before yesterday. Okay, so some of you are interested, we can share with you the judgment of the case also. But that was a very important victory in terms of this thing, because one of the minerals involved there is a nuclear mineral, or what is called a radioactive mineral called monazite. And one of the issues there was that this has been going on for many, many decades. Okay, it's been going on because it's in a faraway corner, nobody is seeing it. And police, revenue, tax, mining, the port trust, because exports are taking place, and people from the Atomic Energy Department up to the Prime Minister's office are involved in this scam. And you need to take action against them. Okay, so this was the period of the mega scams. Can we go back to the slides, Shah? Or is that the last? So it is in this context that we see that the flow after this. Now the latest cases. Okay, now the latest cases are now not just mega infrastructure, mega scams. It's also mega human rights violations. For example, the Bhima Koregaon case. Okay, so Romila Thapar, well-known historian, files a PIL along with 3 or 4 other people, talking about most of the people in the Bhima Koregaon case. They call the BK16 case. Father Stan Swami is one of them who unfortunately died. Okay, so she goes there and says the entire case is flawed. They need not be in. But the present government has chosen to pick up these people because they're all, each of the people who have arrested are very key, very prominent human rights activists. Okay, and therefore you need to teach the entire human rights community in the India, and very importantly, people like you all who are watching this, that if this is the fate for such people, what will be the fate for others? So now they have realized that it is no longer sufficient to just pick up 1 or 2 people and throw them or make it difficult. You actually arrest them and put inside jail, and you don't make it easy for them to come out on bail. Some of the BK16 people have been in jail for more than 5 years, 5, 6 years. They've still not come out, 7 years now. They still have not come out on bail. Okay, the Rafael case, the famous case of the purchase of Rafael. Now, there was a recent visit 1 week back. Some more Rafaels are being ordered. Now, what happened in the first Rafael case? How did a company with zero experience of working on air defense or defense be given such a huge project out of the blue when the army staff itself said it should not be given to them? The Air Force staff said it should not be given to them. These cases went up to the Supreme Court. And the Supreme Court came up with what is called the closed envelope thing, the sealed envelope thing. Some reports were given in a sealed envelope to the judges. The judges saw it. They didn't make it public. Based on whatever was written there, they said, no, everything has been followed, and they closed the case. You have Kashmir lockdown case. Article 370 was decided 5, 6 years after the thing happened. The internet privacy cases, the preventive detention cases, many of those habeas corpus cases have still not been disposed of. The Kashmir cases. Anti-CAA protests still not disposed of. In a recent Hard Talk interview with BBC, you had the former CJI talking about the CAA. It will come in due course type of a thing. Okay, the migrant workers issues and so many causes. That raises the question where I would like to end. Where do we go from here? And what do we as citizens, ordinary citizens, do? So in this class, we have now seen what is a Constitutional Assembly debate, the gift that has been given to us. Arvind, are you there, Arvind?
I've been here actually since 9 o'clock actually.
Oh, sorry, Arvind.
I don't know.
Yeah, I didn't notice you, Arvind. So, yeah. So I'll conclude here saying this is the context in which we have to look at it. Now, Arvind has circulated a paper which is very interesting, Bakshi's paper. Now let's see how we can do it and what do we all do about it in terms of how do we take this class from here? Is it just an intellectual input for us, or can we look at this class as something more than that? I want to leave you with this question, and over to you, Arvind.
Yeah. Just to pick up from where both Suresh and Saila left off, the 2 articles we circulated have 2 different perspectives on PIL. What I think what Suresh communicated as the 70s to 80s kind of a perspective, and the 90s perspective on PIL. And the first piece, which was the Bakshi piece, I mean, if you get a chance, please do read it. It's very useful. Also, because if you notice during the presentation which Suresh made, the slideshow, one of the
petitions of Upendra Bakshi was the state of Uttar Pradesh, right? And that's a case with respect to the condition of women in protection homes and to the amelioration, or bring the attention of the court to the fact that the condition of women in protection homes was very bad in terms of violation of the right to health. Sex workers who are HIV infected, and what should be done? What should be done by the court vis-a-vis them? As Suresh indicated, that the early phase of PIL, what was called PIL, what Bakshi calls SAL, we look at the distinction in a little while, was around the question of uh, the most marginalized sections of the Indian population. And just one point over here, which the Bakshi piece makes, and you'll get it if you read the piece, is why, right? Why did the Supreme Court respond in that particular way in the post-emergency period? What was so extraordinary, or so special, or so wonderful that suddenly the Supreme Court woke up and said, all these people are living in these horrible conditions. We got to do something about it. Is it that conditions were great and fine, 1950 to 1970, 1977, and post-emergency, they, the conditions became terribly worse. The Supreme Court had to intervene. Or was it the fact that the court was blind and did not see what was going on till the post-emergency period? And there's a bit of an institutional analysis which Bakshi does, which is very interesting. He says uh, he says that the reason the court responded in that particular way in the post emergency period is because the court needed to reinvent its own legitimacy. We had a discussion a little earlier, if you remember, on the worst judgment, what I call and everybody calls the worst judgment delivered by the Indian Supreme Court, which is the judgment in ADM Jabalpur, the majority. What did the majority in effect say? The majority in effect said, you might be detained illegally, you might be detained in violation of all laws, but during an emergency, your right to move the court, Article 32, which we just looked at, is suspended. Therefore, you have no remedy. Again, I took you a little bit through the hearings in court, where Justice Khanna asked the Attorney General. He said that assuming uh, a police officer has a grudge and decides to shoot somebody out of that grudge, are you saying, Mr. Attorney General, that there is no remedy in law for the person who is shot by the police officer out of a personal grudge? Didn't they, without batting an eyelid, says, it may shock your lordship's conscience, it may shock my conscience, but that is the law. You have no remedy. And the court, the majority, goes with the logic of the Attorney General and says, you have no remedy. Right? Obviously, the entire institution of the judiciary is completely delegitimized. You look at the judiciary and say, what a joke. Right? That's the sense everybody has. Think that you have again, I remember what we quoted was Hero's comment, which is at the darkest hour, the Indian Supreme Court failed us and made the darkness more complete. Right? And that's the context of the complete delegitimization of the judiciary. And so at that moment, emergency then is revoked, and suddenly there's a bit of a buzz or a bit of a democracy in the air, as it were. And the judiciary, this is Bakshi's analysis, says or decides just to reinvent itself or to re-legitimize itself. What does it do to ensure that to ensure that its legitimacy, to its legitimate again? It invents something called uh, what Bakshi calls social action litigation and not public interest litigation. Again, the distinction I'll just make very quickly. It's an important one for even the discussion of the future. In fact, it's very important for the discussion of what the future of this entire phenomena is. Right? Public interest litigation in the Bakshi analysis is a very undemocratic form. It is particularly the case, right? It's Mr. Upendra Bakshi filing a case on behalf of the suffering women in the homes. He has no connection or which single woman from the home has he met. He does not mind anybody, yet he files a case on their behalf, right? That's what you call public interest litigation. I'm mentioning this because his own analysis, he says that was a mistake. I wanted the case to be about the people who are being represented, not about the person who does the representation. So his point is that was the he's an actor in public interest litigation, and he says that's the last case which I ever filed by me personally. After that, cases were filed by people who were involved with the entire uh, community or representing the community. They were either representing the community rural poor, rural in entitlement litigation Kendra, which files a case, or it could be groups like the PUCL or the PUDR, which are involved in the civil liberties activism, who decide to file or who file cases. Right. So there's a public interest litigation is by sometimes a disinterested person who claims to represent the interests of the suffering people. Right? And the question you can ask is, what do you know of the interests of the suffering people? It's a good question to ask. But the social action litigation should be about a linkage between the group which is suffering and the person who's filing the litigation itself. Right? So the gap you narrow, or litigation, this is worth considering. Litigation can be a way through which a community comes into existence. Right? Again, think of a conventional example, right? A slum is being demolished. What happens? People get together, they organize, they mobilize, and they file petitions as a collective or as a group. Right? Once you file a petition as a group, then that group comes into existence, obviously on the ground, but also vis-a-vis the law. Right? So you have a legal standing because your group which has come into existence. Right? So there's a way in which you become a representative body and you take the litigation forward as a representative body. Again, what is the importance of this? Why am I stressing this difference between SAL and PIL? The importance is this. Go back to the Bakshi piece. There's one very important part, right? Where he talks about the social action litigation phenomenon as not being done in isolation, but done along with the press. The press, in a sense, uh, shall we say, puts the issue out, as it were, or makes the issue more public, and the grouping can take the issue forward. So there's a way in which there's a press gives a certain kind of a publicity to the issue, makes the issue public, and the group is able to take it forward as it. Right. So this is important also because take one more important link one has to make, right? Uh, Litigation is not always about ensuring that the state uh, changes the law or changes its position on an issue. Litigation could also be a way of generating a wider social political consciousness around a particular issue. In which case, then the idea of the press becomes very central and very vital in the fact that you're taking the litigation forward. Point one. Point two is if there's a the added point is if there's a group on the ground, then a defeat, even at the level of the law, means the story is not over. You can continue the struggle using other means at your disposal. Whereas if it's by Mr. MC Mehta, whoever it might be, you file a petition, you lose it, people get in a worse position, and the story is over. Right? So it's very, very important that the community involved be part of the litigation strategy. Right? And maybe I'll get one more point I'll make over here is the other big kind of a PIL SAL story is the entire litigation around the 377, the decriminalization of same-sex relationships in the Indian context. Again, see, think of it this way, right? I mean, if 377 goes, what difference does it make to the lesbian, gay, bisexual, and transgender community? The involved question, but anyway, I'll make this point because see the if you look at the prosecution under 377, right from 1860 to now, right? Consensual sex prosecution, you can find reported judgments of three cases. So the question you can ask is, are you making a song and dance over something which is not, it's a non-issue? The answer is it's not a non-issue, but the issue is really about a kind of a social bias and prejudice which you need to challenge through a legal process. So there's a way in which you think of the law as not just about changing the legal framework alone, but a way in which you mobilize in a larger public sense and challenge public misconceptions around issues. It could be sexuality as an issue. It could be the question of even uh, the question of election, the fairness in elections. It could be the question of caste atrocities, a range of issues in which we know, particularly the question of caste, the question of gender, the question of sexuality. We know that the challenge is not really about getting a provision on the law to go. The challenge is about how, by getting the provision on the law to go, we're able to alter a social or a political mindset and create space for a marginalized group or community, not just in the law, but also in the wider society. So the submission is really this, right? You've got to think of your SAL as a socio legal strategy. Part of it is about ensuring there's a change in the law. An equal part of it is about how do you ensure a change in the way society thinks on a particular issue. And how do the two really come together? So for you, litigation, within this context, litigation or the question of the PIL or the SAL should be you think of it as maybe two strands of a double helix which are tightly wound together. Right? Change in one has to trigger change in the other. Change in the law has to be about change in a wider public opinion, right? And give you again one example. I'll give you one example on this. Uh, when the when the decriminalization happens in 2009 through the Delhi High Court judgment, recriminalization happens in 2013 through the two-judge Supreme Court judgment, after which a range of petitions are filed by parents of LGBTQ persons as well as mental health professionals, etc. Right? And there's a range of TV programs around the time you see Barkadat and others who have all these really wonderful footage of parents of LGBTQ people sitting with their children, right? And it's very interesting. Mothers looking reasonably conventional, wearing a sari with bindi, etc., saying the most radical things, saying 377 should go because it's a affront to my family values. Because of 377, I'm not able to have peacefully enjoy family life. I'm always worried that my children could be arrested, etc. Right? And think of the impact of that, right? You have a normally you're an LGBTQ activist, there's certain stereotypes of the way LGBTQ activists may look, may act, may sound, right? But a mother communicates a very different sensibility, reaches a very different audience, communicates with a different segment of people, right? So a mother saying that is not really so much about the legal strategy in court. In court, how does it matter? You might have a mother no, doesn't really matter. But in the public eye, it's very important. It's very important when you change public opinion. The fact that you have somebody saying the most radical things who looks like somebody you, in this case, for people of that generation, can empathize with, right? So it becomes a way of thinking more broadly. So the my simple point I'm making here is when we say social action litigation, imperatively you're thinking of a litigation strategy which is not just about the courts alone, but on molding and changing public opinion as well. Right? And so you have a slightly, not slightly, you have a much broader conception of what litigation is to me. That's the point I want to make with respect to the question of what social action litigation is. Right? That's one dimension of it. And that's, I think, I mean, I've of course taken it a little beyond where Bakshi ends. Of course, he ends with the birth of social action litigation. Suresh has taken you through one other dimension, which is the question of where social action litigation gets lost in the middle class corruption related issues, forgetting the concerns of the most marginalized. I've tried bringing together saying that, we need to think of social action litigation as in sync with communities and as a broader phenomena than addressing the courts alone. And that's a way in which it can be useful in trying to bring about larger social and political change as compared to purely legal change alone, right? And just it's a lens in which we to think about the law, right? And there are many ways you can think about that. You can think of the Narmada Bachao Andolan case, right? The maybe, maybe the most important thing the case did or achieved is it gave a stay for I think close to 4 years. The Supreme Court granted a stay on the project for almost 4 years, and 4 years is a time during which the Andolan was protected because of the order of the court. They were able to mobilize more widely, uh, try and mobilize and change public opinion more widely. Because the judgment finally was a deep, deep disappointment, but you have to think of it in different ways. Did it provide you the space to challenge current models of development, provided you space, take for a different way of thinking? So just to indicate, you think of social justice litigation in a slightly broader lens than purely what happens in 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 court alone, which means a range of things, right? A range of things, which means that when hearings happen, it's your responsibility to ensure that in the days when the minutes produce minutes, ensure it goes out very regularly, or if the current moment when it's being when some cases are also online and online viewing, etc., ensure that people watch the clipping to get a sense of what actually is going on in the court. I'll give one more example. I'll give since we're on the sexuality question as well. If you see, I saw the hearings in the marriage equality case, again, obviously the judgment was a disappointment, but the hearings itself were a way of again trying to take the trying to take forward the issue that it's perfectly natural, legitimate, okay, or fine for two men or two women to be married as it is for a man and woman to be married. And it's not an easy idea, right, for society to accept because it's a new idea. This, of course, raises another question of a PIL should always, SAL should always go hand in hand with a social or political movement. My own submission on the point is the marriage question, the two got delinked. And it was we saw it almost as a legal petition, which relied on those five judges to grant you the relief, and the five judges failed. At which point you had nothing, because the fact is, if you look at the 377 litigation, it's a 17-year process through which there was a way in which you managed to mobilize a public opinion in support of the question of decriminalization. The protests which happened around the length and breadth of the country, I think 377 should go. But if you look at the marriage question, it's over 3 years. What does that indicate? It's a legal strategy, not a social and a legal strategy. If it is a social legal strategy, your point is simple. It's not easy for our country to accept the fact that marriage should be neutral to gender and sexuality. It's not easy. And we've not had protests, demonstrations, we've not had public discussions on the issue. You assumed, that is the litigation strategy assumed, that you will get it because you had this three sense, you had Mr. Chandrachud as the Chief Justice. And you failed because you relied on a purely legal strategy. When you should have assumed, when you should have thought that a social legal strategy would have meant, even if you got a bad judgment in the High Court, it's a good thing because then you'll file a petition in the Supreme Court. If you lose in two judges, it's a good thing because then you'll file with a larger bench, and that's a way in which you educate the wider population or the wider people on the issue, right? And that's where you failed. Though I say you failed, I think even in the failure, there was a bit of a success. Bit of a success in the sense that if you saw there in the hearings, the one, I mean, my point would be the one issue which was completely delegitimized was the argument of the Union of India. The argument of the Union in India on the marriage equality question was to make the point that marriage is basically an elite issue. The same sex marriage, as Tushar Mehta eloquently put it, he said, Your Lordship, these are elite people. It's not a concern as far as the suffering masses in the villages are concerned. That was his submission. And one of the council, I think it was representing, I think Raju Ramchandran, the point he made, a very, very eloquent point. He said, he quoted Justice Vivian Bose and said the Constitution of India is not for the rich and the elite, to the baker, the butcher, and the candlestick maker. He went on to say that my two clients, one of my client is a Dalit lesbian baker from Uttar Pradesh, and my other client is her partner, who's an accountant from Haryana, and they're in a relationship with each other. So, Your Lordship, simple point is that the by no stretch of imagination can you think of the Dalit woman baker and the OBC accountant as being elite, right? And so, and there's another again activist from Karnataka, Kai Padmashali, who's a transgender person, who's again cited in the judgment, who makes the point that see, I am nowhere elite. And she says that, I don't speak English. I speak basically Kannada as my first language. I'm the bottom reaches of the socioeconomic spectrum. I'm not elite. And I want the right to get married. Right? So there's a way in which there are really powerful stories and powerful narratives which came out of the hearing. But I just think if that powerful narratives and powerful hearings had happened at the Delhi High Court level, you've got an ability or a time to sensitize people. You've been able to do a range of protests, demonstrations, seminars, discussions around the issue. Then you'd have achieved your purpose of a SAL. In this case, you relied on a top-down litigation strategy saying we will deliver as far as the community is concerned, and that's the failure to think of the to think of it as a PIL and not a SAL. You have to think of it as an SAL. That's the submission I want to make based on the Bakshi piece. That's one part of what I want to share. And the last point I want to make on the Anuj piece, Anuj Bhuvania's piece. When do we have? Okay.
We have around 10 more minutes. Go ahead.
Good.
No need to cut it short. It's very enlightening.
Yeah. The point on the again the Anuj Bhuwania piece. Please read it. It's a very well written piece. It's got a certain kind of rhetorical punch. Just as the Bakshi piece has a rhetorical punch, Anuj's piece has a rhetorical punch. It's the exact opposite opinion which is communicating to the Bakshi piece. So it's totally worth reading because you get two completely contrasting perspectives on the issue of public interest litigation. Anuj, of course, uses language of public interest litigation and not social action litigation, right? And it is what he says is that all these points you made, right, about the uh, about the social action litigation, the public interest litigation, which is a relaxing of the rules of procedure, relaxing of locus standi, allowing for establishment of different kinds of use of commissions of as fact-finding missions, and giving enormous power in the hands of the judges is liable to backfire. His point is okay, fine. You relied on the fact that you have these four great judges, right? Krishna, Bhagavati, the four, what Professor Bakshi calls the four horsemen, right? Or the four musketeers, which is great. What happens once your four judges go? What happens once you have judges in today's time, right? Once you have judges who are actually appointed by groups that are completely inimical to the constitution, you're giving enormous power in the hands of those judges because those judges are no more bound by the norms of procedure, no more bound by the basic principles of or what are the facts they can take on board, and they can say anything they want because that is the power jurisdiction grants you. And his conclusion, again, this is I think written, the book must have come out a couple of years ago, before the Modi years or after Modi, just around the Modi, before Modi came to power, I think. And his conclusion is that the judiciary has become, based on one case study, again, the critique you can make of Anuj's book, based on one case study in Delhi, right? He comes to the conclusion that the judiciary has become what he calls a slum demolition machine, right? And it's an exact opposite conclusion which comes to from the Bakshi kind of a piece, right? And his point, of course, is that judges are imbued with biases and prejudices, as we all know. And if the judges decide that, and the cases he cites, for example, one judge says this the slum is there, which is very close to the Supreme Court. What are the slum dwellers? The Sanjay Kishan call, I think. What is slum dwellers? Enter into the Supreme Court, occupy the Supreme Court itself. These are the kinds of loose statements made by judges for the High Court and the Supreme Court, which indicates the way they're thinking. So orders which ask for entire slums to be evicted, right? Yamuna Pusta slum to be evicted in total by judicial order, right? And so there's a way in which enormous power Western judges to do good and to do bad. What is the judge's bad man? I mean, bad man. I'm putting very very badly, but yeah. What if the judge is not imbued with the constitutional values of looking after the interests of the most marginalized? Right? What happens then? Will he, as the Suresh's slide indicates, will the judge use his enormous power to basically act as, in Anuja's words, a slum demolition machine? Or if you see the orders of Justice Gogoi, right, and Justice Nariman, with respect to the NRC, act as a mechanism to set in place in an NRC for Assam authorized detention of people under the NRC mechanism. So the entire mechanism in Assam is set up because of the PIL, right? So there's a range of ways in which PIL can be, in under just terms again, a very dangerous phenomenon. And of course, you take it in today's context. If you say that today we still have some judges who are appointed with a certain sense of constitutional values, but tomorrow, all the judges who are going to be appointed, not tomorrow, as we're speaking, all the judges who are going to be appointed will be judges who are inimical to the values of the Constitution. In which case, what is the PIL jurisdiction going to do tomorrow? Is the question which one has to ask. So again, just I'll make one last reference over here. There's another book which I suggest if you get a chance to please do read. It's called the Mandela Files by, I think, Thomas Packham is his name. But the Mandela Files actually is about the story about this. Actually, Suresh, I should give it to you. I'll get the book for you. It's a story about a lawyer called Sidney Kentridge, who's a practicing lawyer in South Africa, and he practices during the apartheid years. He defends again his claim to fame, the way he puts it. He defends three Nobel Prize winners, right? That is Desmond Tutu, Nelson Mandela, and Albert Luthuli, the first ANC, the president of the ANC, and of course Winnie Mandela as well, and Steve Biko as well. A range of people who are victims of apartheid. He ends up defending. The question to ask is how. I mean, you're writing a book about somebody who's defending Mandela and Luthuli and Biko at a time when the South African Constitution does not exist. Forget PIL or SAL. The Constitution doesn't exist. The idea of equality of all before law does not exist in the South Africa of that time. What then do you do? Right? And here the important point we have to address is you go back actually to the question of, again we go back to our discussion on the minority judgment of Justice Khanna. You go back in a sense to the question of rule of law. Right? Rule of law is something which exists even under authoritarian regimes. Rule of law means you give a reason. Rule of law means that there is a certain kind of regularity and systematicity to the decisions given authority. Even capitalism requires rule of law. Because without rule of law, there's no regularity. How will you move forward? So there's a way in which rule of law might be what is left. If, for example, even if you don't have the jurisdiction of the PIL or the SA, right? So there's a way in which we'll have to. I think we'll have to. There's a question. Spontaneously, I'm thinking. We'll have to think of this question. What is the question of even doing law or law work mean in the context of the ascendancy of the right wing? And maybe one more reference I'll just make one more reference. There's another book which is worth reading. It's called The Dual State by a man called Ernst Frankel. Very interesting book again, because Ernst Frankel was a labor lawyer in Nazi Germany. And of course, Nazi Germany in the sense before the Nazis came to power. And of course, the left was very powerful, very strong, and he was a labor lawyer at that particular moment in time. And the Nazis come to power. And the incredible story which Frankel tells, so we can tell about Frankel's life, is he continued practicing law in Germany right from 1930s when Hitler comes to power, almost I think 1942, almost midway through the worst time of the Hitler regime, right? And finally, in 42, he leaves. He leaves. I think leaves Nazi. Escapes from Nazi Germany. So, what is the law that he practiced in that time? And the interesting point which Frankel makes is that his argument is Nazi Germany is at all points in time what he calls a dual state. That is, it's both the prerogative state, which is the state uh, which is the Gestapo, which is you disappear into the Gestapo. Nobody knows where you are. You're there's no accountability for your disappearance. That's the Gestapo. Whereas the ordinary state, you can still go to the and ask. You know where the person is gone. You go to the police station. You ask for the person to be released, etc. You have some sense of where the person is. Gestapo is a complete black box as it were. So he says even during the Nazi era, your attempt was always to see how do you get people from within the confines of the Gestapo into the confines of the police state, into the confines of the of the normative state. It's a longer story here. I won't go into that, but that book again, if you get a chance, please do read it to get a sense of his argument on what you can do in difficult circumstances. Okay, that's one part of the story. Once that gets confined even further and further, and your litigation becomes even more challenging, then he gets into the question of how do you use the law to build public opinion, right? And so he does these uh, leaflets on the criminal justice system, on what the like a new criminal code, right? What are the problems of the criminal justice system? What are the problems with the new criminal laws, which violate the basic principles of criminal law, right? And he cyclostyles them and tries to get them circulated. Again, not easy in Nazi Germany, but that's the second step. And finally, that also becomes impossible because you can't cycle style, you can't put out anything. It's too risky. Then finally, he retreats inward in the manner of speaking, to write that book called The Dual State, which is a way of understanding the 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 nature of the Nazi state, right? And that's the trajectory of the life of his work. And the good book on that called Legal Sabotage by someone called I think David Morris, if I remember the name, which captures this part of what the work that you can do. So the point of narrating all of this is we need not think of PIL as the only route forward. The range of things one can still do even under difficult or very challenging circumstances. And to think that, from Anush's book, I guess the inspiration we derive is to ask the question, what the social action litigation or public interest litigation mean during the ascendancy of the right group, right? When the power is all on their side, what are the tools that you still have in your hand, right? And how do you push forward with the tools that you have? And would the rule of law be one kind of a framework which one can utilize even under very difficult, very challenging circumstances? Yeah, I'll just end with that. Yeah, sorry, it's 10 o'clock already.
Okay, I think we've had a fairly panoramic view on this whole thing. The key elements of what distinguishes PIL from other litigation, the distinction between PIL and social action litigation, and looking at the point that Arvind ends up with by saying that PILs or SALs are not the only part. There are other ways also by which we can utilize the law in terms of bringing change. That's a point that Arvind, I think it'll be very useful to have the list of books that you talked about, Arvind. If you can share it in the WhatsApp group, so it's there permanently. The chat goes off, so it might be useful. Yeah. So let's have whatever questions that you may have. People, did you all find it useful, interesting? What are questions you may have, doubts you may have? Are there observations that you would like to share? Can we have all of you, as many of you with your videos open coming on? Santhan, can you remove the spotlight? And yeah. If you're reading papers, you cannot but have come across PILs all the time. Whichever part of the country you're in, it's Every other day, there'll be something or the other. So what are your views about it? What do you all think about it? What are the issues you think you would like to take up or see taken up?
Asked.
No, I said, yeah, go ahead, Altaf.
Yeah, so what I'm thinking about, I just was listening to Suret's version of the trajectory of pill, where there is a dilution of the pill over the period of time. And I was just listening to the social action litigation as well as the concept. But how do you see, like, for example, Indian judiciary has been widening the contours of fundamental rights, Article 19, 14, and 21. But balancing, how do you balance your interest when it comes to if I can call it a pill or social action litigation? How do you balance the fundamental rights? Because there is definitely a necessity of having a what do you say, balancing act when it comes to rights. So when you start widening the contours of the fundamental rights, how do you end up in this process? I'm just thinking about it.
Thanks for kicking it off, Altaf. Let's have a couple of voices and then we can have a conversation around it. Is it okay, Arvind? So there's Kanti, there's Satya, Tilo without the face on it, Sendil.
Okay, in case nobody is going, I'll go. So, Arvind, this is a question to you in particular. Could you also put what you said in a historical sort of analysis? Like, for example, the four horsemen, as you put it, they were born out of a certain social, political consciousness, certain context. And from there to now, a certain erosion has happened. And again, sort of again, movements will build up, consciousness will flow, and again, maybe a different generation of four horsemen would come up. So during this entire sort of ebb and flow, basically, are there different strategies in terms of legal social action which anecdotally you can sort of speak about? Maybe sort of a more historical materialist analysis, basically, if it's possible. Yeah.
You know, I think Shanta, the best way to respond to that is actually to recommend readings. So I would suggest, right, the you start with the Bakshi piece, of course, on social action litigation. Move on to the book to read is called it's called Supreme Court in Politics, Upendra Bakshi, right, which has precisely what you're saying. It kind of makes the link between the larger uh, political analysis and the legal analysis. It's a very tough one to do because I mean, once you get into the doctrine of the law, you can't always make that connection to the larger politics, and he does that quite remarkably well. In terms of the post post 70 Supreme Court, and similarly for an analysis of the post 50 Supreme Court is a piece called "Taking Suffering Seriously." Again, again, that's the his analysis. It's a kind of book review, long book review of. Glanville Austin, Cornerstone of a Nation, which again does this kind of a analysis. So I'd suggest you read those two pieces, right, which provides a good account, of the politics. And what again, sorry, the third reference, of course, is on the changing nature of PIL. Right? Again, there's a piece by him on that, the changing nature of the PIL in the liberalization era compared to the earlier era. That's the framework Suresh presented roughly follows that kind of division.
Michael also asked, I skimmed through the two articles. The one by Upendra Bakshi seemed to be seeing a slow improvement in the delivery of justice. But have I got that wrong? Please
Yeah,
excuse my simplistic question. I am not a lawyer and there's so much to take in, question mark.
yeah, and that actually links to Shahantan's point because the two articles are written at different points. And the Bakshi piece is about the origins of PIL. So it's written much earlier in time, and in the late 70s, early 80s. Whereas the Anuj piece is 2018 or 19, much later in time. So that captures the, in a sense, the greater disillusionment of PIL, or not even disillusionment, the sense of what can go wrong with PIL is captured strongly in that article. But I think the point to note is, I mean, again, I wasn't presenting the case that PIL should be given up, but I think how to reimagine it in this particular context, right? How do you think about it as a socio-political process is really the point I wanted to make. Yeah.
Thank you.
Actually, Arvind, there's a professor called Professor Gitanjoy Sahu, who teaches in PISS. His PhD is studying the PIL from an environmental law context. So he makes this distinction. In fact, the last part of our framework was sort of something that we've been discussing with him for a long time, and which he has expanded. That right now it's on the cusp of these three things: the individual rights versus developmental rights versus environmental. Broadly, bulk of the things are going around on those issues, where social action litigation or public interest litigation. And he says, so when it is individual or community rights vis-a-vis environment, courts tend to look at it in terms of environment. But if it's environment vis-a-vis industry or development, invariably courts tend to only view at it in terms of industry or developmental rights, and never in terms of environment. And we are seeing this series of devastating PILs dismissing many of these issues. See, but one issue that you talked about, and that's an issue that we need to keep in mind, is that if you were to strategize on PILs, and that's a portion that we take in PUCL, that you don't go rush to court. Okay, you first always go to court for a PIL only through somebody who's affected, representing that community. Only if that person is not available, or there are structural, systemic issues about them taking it up, then as an organization we swing in, or even any other organization should swing in. Okay, that's a second type of an issue that that is generally talked about. Okay, and third, we are now living in a situation in 2025 where many high courts are imposing costs on people filing PILs. Okay, in fact, in our high court now, PIL filing has almost stopped. With the Chief Justice who has come from Bombay, with the commercial law background type of a thing, civil law, completely zero. It's imposing costs left, right, and center. Okay, so all the things. Doesn't mean the need for a PIL or to take up these issues has gone. It's just that courts are now no longer responsive to these issues. Okay, that underscores the point that I think Arvind was talking about, which I would like to emphasize. Without citizens' mobilization and citizens' movement, there's no point in going to courts today. Unless an issue becomes a public issue, it becomes an issue of public discussion, public mobilization, public debate. Okay, and it is there in public discourse. It again becomes a fight between two sets of people or three sets of people. And lastly, the danger in this public interest litigation, you remove the context of agency of people to bring change, political change, by turning it into a fight between two lawyers in courts. You see, or a set of lawyers in court. So people are effectively defanged through these PILs, and that we need to keep in mind before we go into it. You know? And these are important considerations that we need to have in mind in terms of choice of going to PIL. Saila and I, we take a very conservative look on PIL. We go only when it's absolutely necessary. Otherwise, you don't go. You try out individual litigation, which Article 226 permits us to do. Just a little of a background. Ravi, you were wanting to say something, Ravi?
No, I think today was initially quite heavy, I thought, but then it's also after hearing the kind of change in the character of the judges over time, and the kind of cases that like right now what you are saying is that the high courts are not interested in taking up PL cases. It sounds quite quite disturbing actually. And like what you say, how do we go ahead in terms of making some issue a public discourse? It's going to be a challenge that I keep thinking about. So, just a thought.
It is. These are. We'll come back to this. Maybe some of the others. Satya, anything that strikes you? Subhashri, unusually quiet today. Sendil, Tilo, Selva.
In the meantime, Michael writes another question. Would it be appropriate or useful to describe the matter of the PIL initiated at Sitilingi related to regulation of medical care and drug costs? Something that involves Ravi as well.
You want to describe it? Go ahead, Mike.
I didn't want to describe it. I mean, it was about the fact that you know, most of the urban population of India now use private medical care, and all that area is, I gather, the regulation is very little or doesn't exist, and there are cases of of exorbitant costings and so on, affecting medical care and drug costs and so on, and Barefoot Academy led a 3-day Kudam about the economy, about the of healthcare, and so this suggestion of a PIL came out of all of that, and I don't know where that's got to, but I just wondered if there was anything that relevant to today's session that would be that it could be an example or something of I wasn't wanting to try and
very briefly.
Yeah.
Yeah.
Did I get that right? What I've said, did I get that more or less right?
Yeah, you got it right. Yeah. Just to put the context, Arvind, it was a set of workshops we were taking for doctors. And one of the issues that came up in that thing in which Ravi was also there was about fixing up hospital rates across India. Right now, it's exorbitant in any of the private hospitals. Whatever strikes them, they do it, and people are getting skimmed in these things. So one of the issues was that there's an existing PIL where they said that the government of India, through the medical council, should what they call the Medical Commission of India, should necessarily fix rates for private hospitals across India. And of course, it will vary from state to state, but there should be so that patients know exactly what they are entitled, what they're expected to pay. So in that PIL, the doctors who went through this training program where we talked about rights and other things, decided that they should intervene, and they had a wide-ranging exercise of surveys and reaching out to people in different states to put together a cogent argument as to why private hospitals should be regulated much more than what they are now in terms of the rates. So that's the context that Mike is talking about. See, I don't think, Mike, we can give any specific answer, good, bad, yes, no. These are very contextual and varies from issue to issue. On the issue of patient care and patient thing, you don't have a larger patient care movement in India, unfortunately. So those times, it might be necessary for public interest litigation, type of litigation. So that's my personal take on it. Though, if you remember, you were there in that meeting, I told them, first organize protests, organize movements, organize seminars, organize conferences, so that it becomes a public issue. And then when you go to the courts respond to it very differently. But again, that's an issue of tactics and strategy of PILs.
I think for me, this was very interesting. I joined a little bit late today, but it was very interesting for me it kind of binds everything that Barefoot Academy has been doing, that you need public action, you need the people to be involved in something, and it kind of puts everything together in context as to why the public interest litigation by itself cannot stand on its own without having a social action around it. So that really helps in putting things in perspective for me.
Thanks, Thelo, that you put it very nicely. Any other questions, comments? We should close. We are at 10:22. Yes, somebody was saying something?
Yeah, this is Subhashri. Not a question, but just a thought. Typically, for example, in the US, um, a matter of public concern would be brought up via a law introduced in a lower house and passed. And the PIL seems to, I know in the food security case, there was a law that was passed after the PIL and because of the PIL. But it seems like a lot of these issues should actually have a law regulating them.
Yeah. Arvind, you want to say?
So, Suresh, please go ahead.
No, Subhashi, yes and no. If there are laws which are clear and which empower people, give agency to people and protect their rights, that would be ideal. But we are not living in an ideal world. One. Two, governance failure has now become structural. It's not poor quality of government officials. Governance itself has become so corrupt and inept. The governance failure has become systemic. Okay. Now, in these conditions, to expect laws to be passed would be again ideal. It's something that we should work towards. In the meantime, what do you do is a question. And that's why many times people go to courts on a variety of issues. Okay. Now, public interest litigation is a very unique form of litigation in the world. It exists only, to my mind, only in India. Some other countries are experimenting with it, but it's not really grown. It's gone through the whole process of up and now it's on a down process, which means that if it could go up, we'll have to mobilize people to make it go up again. And we shouldn't necessarily take it as a negative thing. Let me give you an example, just to say that I'm not talking through my head. 1.5 years back, Supreme Court a judge who was very pro-establishment, who in his attitudes was not at all progressive, imposed fine, contempt and fine on Prashant Bhushan. Okay. And there was a nationwide furor on that. Okay. And people across the country came together saying this is not accepted. This was a case which came up from the public interest context and he should not be. And the judge and the bench walked back on it. There was other case of Corona. If you'll remember very famously, people were walking from one end to the other end, walking thousands of kilometers. And when this matter was taken up in the Supreme Court, again, this is where Arvind would come in to say that it was an individual who went, Harsh Mandar, who went in on behalf of a lot of people, but he went in where others did not go in. The Supreme Court refused to take it on file. Okay, but there was again a furor at that time saying, and the court said, how do we know that people are walking on the road? If they're walking on the road, that's their problem. Okay, I mean, this is how careless the court was. If you remember, at the same time, about 16 people were sleeping because they were tired on the train track somewhere in Andhra. A train came and mowed them down. All 15 or 13 or 15 of them were killed. And the court, when the matter was taken up, said, who asked them to go and sleep there? Okay. Okay. Now you can imagine people in Corona, lockdown, they were sleeping there because thinking that no train is going to come. Now, in the Corona case, the same bench, about 2 or 3 weeks later, again, because of the furor across the country, mobilization of people across the country, mobilization of opinion on the issue, then subsequently took up the case as a public interest litigation case. So just to show that you cannot subvert the power of people and the need to mobilize people. And this is where the danger lies, which is that of middle-class people, educated people who become champions of these things and want to push it. It may be a genuine issue, but they push it in terms of a agenda in which people are not engaged. And that's where the problem lies. I'm being very careful. People are not engaged. Doesn't mean that it's not relevant to the people. Okay. So advocates also play a role, activists play a role, intellectuals play a role in this. When we look at politics as individual adventurism, you will end up with the type of PILs we have today. Okay. I think we should end here. It's 10:27. This is the longest we have gone. Saila is already saying you've broken all the records now, 10:27. Okay. Chalo. Everybody,
But
good night.
thank you. Thank you for this very different way of looking at it.
Yeah.
It was worth the half an hour extra.
Okay. Thank you, Tilo. Okay. Bye.
Bye.
Next class will be the last class, and then we'll have an open session after that. Yeah. Okay.
Thanks
Bye.
for joining. Bye-bye. Good night.